let's turn straight to entertainment attorney Tre Lovell on this. Tre, it's good to see you again. Let's talk about this. Elizabeth just reporting there's this motion to dismiss from the defense on grounds of allegedly withholding evidence. Do you think this has a realistic chance of being granted?
I mean, probably not. I think it's a good motion and it's brought on meritful grounds. I mean, it does seem the prosecution withheld evidence pertaining to the bullet and how it got on set. The defense team was entitled to review that and may have changed their strategy a little bit. You just don't really know, but you never withhold evidence, especially if it's exculpatory evidence from the defense. It happens. It shouldn't happen, and they're right to bring the motion, but I don't think it's going to be strong enough to actually merit dismissing the case.
Okay, and let's talk about the other thing that people are really closely watching today. Hannah Gutierrez Reed expected to take the stand. We heard Elizabeth saying there she's likely to plead the fifth there. Practically, what does that look like? Does she have any sort of prepared statement? Will she contribute anything, or does she literally go up on that stand and pleads the fifth and contributes nothing, says nothing today?
Yeah, so the issue with her is that she was convicted and she's got it on appeal. And so her attorney is worried that any testimony that she gives, should that appeal end up in a retrial, could be used against her in the retrial. And remember, the prosecution or the judge has not given her immunity, so she's exposed. So as a result, she's entitled to prevent herself from self-incrimination. But you got to remember, the Fifth Amendment is not a blanket immunity. It's a question by question analysis. So you can't go and say, hey, I got an appeal coming, I'm not going to testify at all, because there may be questions that are not subject to the immunity. So she's going to come in, and there's a couple ways that they do it. Either the judge will talk to her, and if the majority of the testimony is going to be Fifth Amendment, they may not even have her testify. But most of the time they'll put her on the stand, go question by question, and then she'll be able to invoke the amendment if it's applicable.
Yeah, and we're taking a live look right now. We're expecting to see the bullets, just so that the viewers understand what we're looking at right now on the screen. Let me ask you, can you give me an example of a question she might be asked where the Fifth Amendment would not apply, where she would be compelled to answer?
Where you're from? You know, have you worked with this particular supplier? You know, I mean, kind of general background stuff. You know, were you an armor on the set? Things like that have already been established. But those aren't the questions that are going to be asked.
Understood.
The questions that are going to be asked are going to relate to how did the bullet get on set, Alec Baldwin's, you know, actions and conduct, and things like that that are going to be material to Alec Baldwin. So, you know, general background questions, general questions that have already been established, you know, are not really of concern, but those aren't the questions that are going to be asked.
Yeah. How does that impact Baldwin's trial? Is it a positive thing or a negative thing for Alec Baldwin that she will likely not be answering anything substantive today?
It's a positive thing, because what Baldwin wants to get in are statements that she made when getting interviewed to the prosecution and the detectives about how I could have checked the gun better, I could have done this or that. That helps Baldwin. And he can get those in because they're an exception to hearsay, they're declarations against interest. But if she's not there to testify, the prosecution can't cross on it. And so that's going to basically just allow the defense to get the shot at the apple, and the prosecution doesn't get to respond. So I think it helps the prosecution if they can get those statements in, but there's no cross.
If Baldwin were your client, would you urge him to testify in his own defense?
God, that's a really good question. 99% of the time, the defendants do not testify. And the reason is because you're going to be subject to the cross-examination that could affect your credibility. If one response goes astray and the jury thinks you're lying, they could taint the whole testimony. So it's very dangerous for a defendant to testify. So unless it's absolutely necessary. Originally, I thought it may be necessary because one of his contentions is he didn't pull the trigger. And because the prosecution has evidence that the gun didn't malfunction and he did pull the trigger, and Baldwin's team was unable to have their own expert do analysis because the gun was destroyed, that may be the only source of testimony to get that in. So that may be the one hinge point that they may think about it. But generally, as the trial goes on, if they really think they've got you know, reasonable doubt, they won't call him.
Tre Lovell, I appreciate the analysis and time today. Thank you.
Thank you.